I'm thrilled to see you here for improving responses to people with mental illnesses at the pretrial stage, essential elements. I'm Hallie Fader-Towe. I'm a Senior Policy Advisor with the CSG Justice Center. I have the honor of being one of the authors of the document on essential elements. Our document, which we're going to be going over today, was ably advised by a group of experts from around the country, including Glenda Flowers from the District of Columbia Pretrial Services Agency. And I'd like to have Glenda introduce herself as well.
Good afternoon, everyone. My name is Glenda Flowers. I am in transitioning from a position as a Supervisory Pretrial Service Officer to a Clinical Support Specialist. I've been working at DC Pretrial for about 15 years here in the district. Are anyone here from the district? Oh, okay, even better. So pretty much we're tasked with pretrial services is supervising individuals who have pending criminal matters in the District of Columbia, and I work specifically in the mental health unit to supervise those individuals who have serious and persistent mental illnesses, who may also need substance use disorder treatment.
Thank you. Would love to get a sense of who's in the audience. Can you raise your hand if you're working on a program that already does pretrial release for people with mental illnesses? Great. And if you are an attorney, a judge, a clinician, a supervising officer. Okay, I missed a bunch of you. What did I miss? Administrators. Administrators. Great. So we'll be focusing a lot on what it would take to put something like this together, recognizing that our audience is pretty interdisciplinary, but there are a lot of folks who are in the position where they need to be thinking about the components to put in place. The way that our session so our goals for you for this session are that by the end you will understand the existing recent research on mental illness at the pretrial stage, that you'll be able to identify the essential elements to include in the development of local policies and programs, and the hint is they're on the handout I gave you. Describe strategies for overcoming common challenges, and this is where the rubber hits the road. This is why we have folks like Glenda who've been working in these programs for a while, and smart folks in the audience here who can help problem solve around different strategies. If you don't have a copy of the handout, it is on the flash drive, and it's also available online, and I'm happy to provide copies of the presentation if you're interested. We'd also like you each to leave with a concrete step for when you go home. It doesn't need to be, I will start a pretrial services program for those with mental illnesses, but we'd like you to think about one thing that you can take from this session and bring home with you, even if it's a conversation, if it's a fact that you want to share. These conferences, we're trying to provide you lots of information, lots of food for thought, and we wanted to take a moment to pause here and say, okay, what's one thing I can pull down that's going to lead to action when I get home? So why focus on pretrial and behavioral health, known knowns and known unknowns? The spoiler for this section is there are a lot of things we know we don't know. Then we will go into essential elements themselves and finally the concrete strategies. So one way of entering the why pretrial and mental health is data. Why not? I'm showing you a chart that some of you may have seen earlier from Dr. Osher. This is actually from the New York City Department of Corrections, with some good news and some bad news, right? So on the good news side, they see that their admissions are going down. They're going from 13,500 to 11,900. That's good, right? Admissions going down. Unfortunately, at the same time, the admissions of people with mental illnesses are going up. They're going from 3,000 to about 4,000, making individuals with mental illnesses a greater portion of the average daily population. So there are more people with mental illnesses in jail, and they're making up a higher percentage of the people who are in jail. New York.
Are those self-reported diagnoses or actual diagnoses? diagnoses by professional clinicians who've done the dual disorder assessment?
So this is data from the New York City Department of Criminal Justice. It's based on individuals reporting for services.
Thank you.
So New York City had this set of data. We know our jail admissions are going down, but our average daily population with mental illnesses is going up. My understanding is that this is a situation many of you may be seeing, and they wanted to use data to understand why that was the case. So we were able to look at who was in their jail population and see that in New York, like many jails in the country, about 60% of the people who were being detained pretrial. That lines up with the Bureau of Justice Statistics numbers around the country. So about 2/3 of people in jails are being detained pretrial. And for those with mental illnesses, that's the call-out box you're seeing there. The average length of stay, the blue bar, for those with mental illnesses was about twice as long as the average length of stay for those without. So that helps explain why the prevalence is so high, right? The people who are coming into jail with mental illnesses are staying for much longer, particularly pretrial. Is it a question about the data?
It is actually.
Okay.
Just a comment that I noticed. It's not including VOPs, which in our jails is a big portion.
Yeah, no, it's a great point. It's a great point. So pretrial, a significant portion of the jail population. Individuals with mental illnesses who are being detained pretrial, often staying for longer. This is a lot of text. I'm going to talk you through it. This isn't what anybody wants, right? If people who have mental illnesses are being detained for significantly longer, new research, particularly funded by the Laura and John Arnold Foundation, has been showing the harmful effects of pretrial detention on individuals' trajectories moving forward. The first set of findings is from, and all of these findings and the research report are available on the Arnold Foundation website. They looked at large data sets from around the country and found that looking at similar groups of people, controlling for risk level, controlling for charges, male, female, all sorts of things, when you compared those who were detained for the whole pretrial period versus those who were released for part of the period, the people who were detained the whole time were 4 times as likely to get a jail sentence as those who were released at some point. That their jail sentences were likely to be 3 times as long. So again, that's controlling for charges, controlling for risk level. Similarly, 3 times as likely to get a prison sentence. The prison sentence was likely to be twice as long. So the only thing that's changing there is the pretrial detention. Particularly bad for people who are at a low risk of pretrial failure. They found that when people who are low risk of pretrial failure were detained for 24 hours or more, when they were released, they were more likely to be picked up on new charges while on pretrial release, and stunningly, more likely to be rearrested 2 years later. So the pretrial detention has the impact not just on that current offense, but potentially on that individual's trajectory moving forward. Those findings held for people who are at a moderate risk, did not hold for people at higher risk. So taking away a bunch of bullet points, that pretrial detention can lead to a significant amount of increased criminal justice involvement, either through a jail sentence, a longer jail sentence, and even potentially future recidivism, particularly for those who are at a low risk of failure. And from the sessions you just came from, this is going to sound very familiar to what you heard about adults post-adjudication, right? The idea of over-supervising people having poor effects. This is just for a pretrial population. For defendants with behavioral health needs, now I'm speaking from our friends in social science and clinical, who would tell us that obviously time in jail means a separation from community-based treatment and supports, putting an individual at risk of losing health insurance coverage, housing, employment, and obviously is something that we're paying for as taxpayers. So a number of reasons why these longer lengths of stay for individuals with mental health needs, pretrial, not necessarily in the interest of these individuals, not necessarily in the interest of our systems. Why is it happening? Well, this is, I mean, when we go to focus groups, when we talk to people, the first obvious answer is, well, we can't release them safely, right? If these individuals are released, they're going to fail to appear, they're going to commit new crimes. And we want to try to disaggregate that, right? We want to say, I think you're all leaving the sessions you just had being a little savvier about the word risk, right? There are a lot of ideas that run under that word. In this context, we're talking about a risk of pretrial failure. So that's a failure to appear at future court appearances or a risk of new criminal activity while on pretrial release. In some places, they will measure a risk of a technical violation while on pretrial release. And sometimes they'll just say risk of pretrial failure is any of those things happening. Question mark about risk of violence. We have a wonderful group of clinical psychiatrists and judges who have been working on a set of consensus statements about what the research says about individuals with mental illnesses and risk of violence that will be coming out soon. The spoiler for that is to look at similar factors for those with mental illness as those who don't have it. So does the research bear out that hypothesis that individuals with mental illnesses would be at a greater risk of pretrial failure on any of those dimensions? A meta-analysis was published in Federal Probation a couple of years ago. So a meta-analysis is a study of studies trying to identify the factors that were most predictive of pretrial failure. You'll notice that mental illness is not one of them. They're all mostly administrative criminal history factors. The Laura and John Arnold Foundation, also available on their website, did a incredibly large study, couple 100,000 cases from around the country, looking at factors that were as predictive as possible for risk of pretrial failure. And again, mental health was not one of them. These are, again, all static criminal history factors that showed up as the most predictive. So adding questions about mental illness or substance use did not make the instrument that they were developing more predictive. It didn't make it more accurate. So does that answer our question? Not exactly. So what I'm showing you right now is a chart that was developed by the Pretrial Justice Institute that shows, this is available on pretrial.org, where they looked at factors that are in different pretrial risk tools. And you'll notice the Florida pretrial risk tool and the Colorado pretrial risk tool both include questions about mental illness. Those were tools that were developed based on empirical analysis and found those factors to be predictive. When you look at the questions behind those factors, many clinicians, I think, would not consider that a diagnosis. They're questions about, have you accessed services in the past? The Florida tool is, have you accessed mental health or substance use in the past? So one of the takeaways from this set of research and from talking to the people who've developed these tools is that we are truly lacking good data that would inform conclusions in this area. As you have probably heard throughout this conference, very few jurisdictions, if any, are able to do a reliable screen for mental health need for every single person who goes through pretrial detention. And that would be a prerequisite for determining whether mental health need is predictive of pretrial risk, right? You would need to see that whole set of data in order to be able to analyze how predictive that is. So my exciting conclusion here is Maybe. We can ask Glenda what she's observed in the District of Columbia. I know there are a couple of researchers who are working on identifying data sets that might help answer that question. There's an RFP open right now for research on this area. So if you have a great data set or a great program, please help contribute knowledge in this area. But this is what we've got so far. So if it's not that they're too risky to release, is it that they're unable to meet the conditions of release? So people with mental illnesses are being detained longer because they can't meet the conditions that a judge has set. And again, I'm going to go look at the New York City data. Interestingly enough, for both felonies and misdemeanors, bail was set at pretty similar amounts for individuals with mental illnesses and non-mental illnesses. So it wasn't like judges said, oh gosh, Hallie looks scary, set bail super high for her. But what was happening was that the people with mental illnesses were making bail much less frequently. So here I'm showing you that about 21% of the people without mental illnesses made bail, whereas only about 12% of those with mental illnesses made bail. And that when people with mental illnesses made bail, it took them 48 days versus the 9 days for those without. And again, those of you who are in this work, I'm seeing a lot of shaking, like, yeah, that makes sense. These aren't people, a lot of these folks don't have a lot of financial resources. They don't necessarily have close family or friends who would help them out in this sort of situation. Time to treatment placement. This is something we've heard anecdotally, haven't seen a ton of research on, but would love to. That judges are saying, yes, Hallie, you can be released pretrial as soon as you've got a spot in a community-based provider. Good luck with that. And so that folks are waiting in jail for a spot to open up or for the judge to have enough information to make a release decision. This is something that we heard in a lot of focus groups. And a question about what do we actually have in place? Do we have something like what DC has, a pretrial services officers who are specialized in working with people with mental illnesses? Do we allow for diversion early on? Or do we just have a mental health court that's post-adjudication? What sort of options do we have? What should we do? This is where I'm pulling together some of the research about practices. This is from the National Pretrial Working Group. There really does seem to be a consensus coming together that using an objective tool to inform pretrial release decisions helps. This is not a threat to judicial discretion. This is giving judges helpful information to inform their decision making. The Arnold Foundation has findings that without using objective research-based pretrial risk tools, jurisdictions understandably wind up letting out people who are high risk and detaining people who are low risk. Not having that information means that we're not sorting people the way that we would want to. Increasing evidence for using a structured decision-making process. A lot of jurisdictions are calling this a praxis because why not? The idea is that there would be a chart in place that matches pretrial risk scores and often charges to different types of release decisions. It helps with consistency so that low-risk people are following a similar decision path, middle-risk people are following a similar decision path. Some research came out this summer saying that, this is from Luminosity, and I've got the citation down at the bottom, but it's luminosity.com. Looking at, they did a controlled study with pretrial services agencies in the state of Virginia. Some pretrial services agencies got training and a decision tool. So the officers, the judges, used a structured decision-making process to release people. Some of the sites didn't get that. Some sites got an additional set of training. And what I'm showing you now are the findings from that, which are pretty encouraging, that the Virginia defendants in the groups using the praxis, so getting the training and the structured decision-making, were 1.3 times less likely to fail to appear and 1.3 times less likely to commit a new arrest while on pretrial release. So those are some promising findings. It also might make sense to consider different supervision approaches. So this is, again, pulling very much from the post-adjudication literature that you would supervise a low-risk person differently than you would supervise a high-risk person. In Virginia, they developed something called STEPS, which was an approach for pretrial supervision based on the defendant's motivation. The sites that you got the additional STEPS training and actually used that approach were 2.2 times less likely to fail to appear, but they did not have a difference in the new arrests. So something new, some promising findings. Other things that we know are good, you've heard about the importance of screening for mental health as early as possible. Good, difficult to do. We know that there are information sharing considerations, particularly early in a case, right? These are defendants who are still innocent until proven guilty. They have cases pending. We're also talking about behavioral health information, a number of places where we would want to be thoughtful about how information is collected and shared. Again, conversation about what, how risk assessment would be applied and used with a structured decision-making tool, and identification of appropriate community-based treatment and supervision. So that is the universe of why pretrial mental health, some of the things we know, some of the things we hope we know, some of the things we think we know, some of the things we know we don't know. With that state of affairs, the obvious thing to do would be writing a white paper. The Justice Center has worked on a number of essential elements documents. The concept is to try to distill what good policy or practice looks like in a way that could be applied across diverse jurisdictions. So we'll be talking about how DC has applied these elements, but they should be equally applicable in Calaveras County, California, or Hennepin County, or any of the counties that are here today. You have a number of these on your flash drives. In addition to pretrial, you also have law enforcement, mental health courts, and specialized probation. So our process for developing the pretrial essential elements, we had some attractive people. Now we have really some wonderful, thoughtful advisors, judges, prosecutors, defense attorneys, researchers, clinicians, supervising officers, pretrial services directors, TA providers, coming together to try to agree on this is what is most important, and this is what the research says, and this is what we think the best of practice is. The elements were road tested with the pretrial work group, so I presented an initial version to that group to hear what they thought. We tweaked, and we unveiled the elements this summer at the National Association of Pretrial Services Agencies conference. And this is what they look like, and they're on your flash drive. So just to explicate a little bit what pretrial stage means, we started at arrest because we already have essential elements for law enforcement. So this assumes somebody has been arrested, and it covers creating diversion programs, like a post-booking diversion program, and what that could look like, as well as, informing the judge's release decision, the conditions of pretrial release, modifications to those conditions, what pretrial supervision looks like up to the moment when the case is adjudicated. Here are the elements. If you were here, one of the first people here, you got a handout. If you didn't get a handout, here are the elements, and they're on your flash drive. We're going to spend the rest of our time together going through these, describing what they are and how they can be applied. We can divide our time up equally in 7, or I can take a poll to see if there are some of these that you're more interested in. For example, you might be very curious about what supervision looks like in Glenda's program, but less interested in who she has in her collaboration or how to get people to the table. So I will say these slowly, and I'd love to have you vote on the ones that you'd like us to spend some more time on, and we'll just try to budget our time accordingly. And obviously, we're both here to be resources on this as you're working on it. So the first element, very intentionally, is collaboration. Our advisors felt it was incredibly important that the right people were at the table from the beginning to weigh in on the development of this sort of initiative. The second element, again, very deliberately, was around training. They felt that without training for all of the constituents, a lot of these policies and practices don't happen, or they don't happen correctly. So we talked about what that training might include. Pretrial release and diversion options. This is more the legal structure for what's available. Informed decision making. This is the sort of information that the judge or the prosecutor or the defendant has at their disposal if they're opting into a program or making release decisions. Quick and appropriate behavioral health support and services. So this has to do with screening and assessment and the sorts of treatment. Community supervision and treatment at the pretrial stage. Okay, what happens to someone when they're back in the community? And finally, you know it had to be there, performance measurement and data collection. We did have some back and forth about whether this was going to be first or last, and it's woven throughout, but also as its own element. So those are our 7 elements. Let me get a pen so I make sure to take good notes. Folks who would like us to spend extra time on element 1? Okay. Element 2? Element 3? Okay. Element 4? 5? 6? Okay, 6 is a winner. And 7. Okay, great. So we'll go through everybody, but we'll particularly spend time on 2, 3, 5, and 6. This is all on the drive. So Glenda, if you could talk a little bit about collaboration and who's at the table in DC and some of the challenges or sort of strategies that y'all have learned.
Sure. Do you want me to come up there? You can say that. I'll say that. Okay. Collaboration is key to what we do on a day-to-day basis. Hallie mentioned who's at the table. Well, we try to have as many individuals as possible to make an inclusive process, from individuals from pretrial services to the judges, to the U.S. Attorney's Office, to individuals from DC Jail, to various community-based mental health providers. We meet sometimes once a month to quarterly just to discuss different things. Our drug court program within pretrial, actually, they meet on a day-to-day basis to do a staffing process where they're staffing the cases that are actually on the judicial docket that particular day. And that consists of the U.S. Attorney, someone from the Defense Attorney's Office, a pretrial services officer, someone from our toxicology office, because we do drug testing on a daily basis. And the judge is actually there, and some of the judge's staff to go through the cases they're going to have, discuss different things prior to holding up the actual courtroom process on a day-to-day basis. So it's kind of helping the process speed along as far as drug court is concerned. As far as mental health court, we have various community-based mental health providers that actually come to court with their defendants on a day-to-day basis to actually present the judge and give vital information as far as compliance with mental health compliance, as far as taking medication, as far as reporting to us, pretrial services, on a weekly basis. And not all the mental health providers will report. It depends on the level of case management they have with individuals. Some of the mental health providers actually have more contact where they're actually in the community meeting with them. We have a mobile crisis unit that will go out into the communities and make contact with our defendants. We have a very large homeless population, so for the most part, in order to see them on a regular basis, you have to go out there to actually meet them. Unfortunately, pretrial is not mobile at this time, so we rely on them coming to see us as instructed by their conditions of release. And oftentimes, they don't report as often as they should because of they may not have the funds, or sometimes they're not compliant with taking their mental health medication, so they're not necessarily stabilized, and reporting to us is not necessarily a priority. But we keep regular communications, because sometimes they may not be compliant with reporting to us on a weekly basis, but they may report to their mental health provider, sometimes just to get their money, because a lot of times their services are connected to their mental health provider, so they'll receive their Social Security funds or any type of money towards groceries and things like that. Their mental health provider will be considered their payee, so they regularly make contact with going to see their mental health provider. So we communicate with them on a regular basis to see if they're not compliant with us, that at least they're compliant with them, and then report that information to the courts. So as I stated, collaboration is extremely important in order to managing the whole person. It's like a village sort of communicating to supervise the individuals.
Thank you. Training for everybody. So some of what we heard about was the sort of cross-training. Can you hear me? No. Some of what we heard about was the cross-training that you're going through right now, learning more about the justice system, more about the behavioral health system, to have better appreciation for each other, learn everybody understanding what pretrial risk assessment is. Can you talk a little bit about some of the training that you're familiar with or that you've been involved with in DC?
Sure. Has anyone actually been trained in mental health first aid or is aware of mental health first aid? Okay, that's great. Mental health first aid, for those of you who are not aware, was actually introduced in 2001 in Australia, and it was brought to the United States in 2008. Pretty much this training is for the layperson, the non-clinical individual, to just receive some information on how to assist someone who may be in mental health crisis. As you can see when you turn on the news on a daily basis, a lot of these mass shootings or things like that may involve individuals who've been previously diagnosed with a mental illness or may be in mental health crisis or haven't been diagnosed. And this information, this training it's sort of equivalent to like CPR, try to teach you those basic tools to assist someone who may be in crisis. Not to be able to diagnose anyone by no means, but to assist someone to get them to appropriate help. Motivational interviewing is very important. And the trainings is not necessarily just for the population that we service, but for the individuals who's providing the services, the individuals that you work with every single day. You know, you have the, as we call them, defendants in DC, the defendants that we service, but also just to be able to have that support so you're able to, we're the helpers, so sometimes the helpers need help. So it's very important to make sure that we have this ongoing training and support to support each other. Mental first aid, motivational interviewing. Let's see.
With the National Pretrial Work Group, a number of the membership associations are doing profession-specific training on pretrial. The International Association of Chiefs of Police has had pretrial training at their conference. The National Association of Counties has had pretrial training. A new online training is going to be rolling out in 2016 called the University of Pretrial, organized by the Pretrial Justice Institute, so you can watch for that on pretrial.org. The National Institute of Corrections does training for pretrial executives. The National Judicial College has pretrial training for judges. So, you know, your TA provider or going to pretrial.org, there are a number of different professional trainings that you can access to help get your teams conversant in where there's research, where there isn't research in this area. This was one of the priority areas that you identified. Did anyone have any outstanding questions on training? Nailed it, huh?
They have mental health first aid training specific to law enforcement.
Absolutely, that's correct. Since it was introduced in 2008, it's expanded where they have mental health first aid for youth, the youth population. I'm actually a mental health first aid trainer, but just for adults. So they have the youth population, they have law enforcement, they have one specialty for veterans, for rural areas, for older adults. So they're expanding to make it centralized to specific populations, so you'll have a better understanding.
Okay. Other questions or comments on training? In the back, sorry.
I've been fortunate at our facility to have the mental health workers training with the sheriff's staff, to have that cross-training. But
Great, great. And in the front?
Would the women's risk, the women's risk
Mhm.
needs assessment developed at University of Cincinnati be considered a pretrial screening or assessment?
There was an adaptation of the WRNA. So the question is about the Women's Risk and Needs tool as a potential pretrial risk tool. And I know there has been an adaptation of it for pretrial. Krista Gehring, Gehring at the University of Houston has worked on that. And I can give you her contact information.
Thank you.
Mhm. Other questions on training? All right. Release and diversion options. So what options do judges and prosecutors have at their disposal in terms of how a case proceeds? Some of this is statutory in your states or constitutional in your states. Some of it is ad hoc. Some of it is through court rules. If you are curious about the state legal framework in your state, the National Conference on State Legislatures has a pretrial laws database that goes through pretrial release statutes and diversion statutes. And it's a great place to start. And you can also obviously look at other programs that are in your state. I always find this tricky. You were talking almost interchangeably about pretrial, drug court, mental health court. Can you talk a little bit about the different options for defendants in DC?
Okay, so within Pretrial Services Agency, we have two main courts. We have our drug court program, and then we have our mental health court program. So drug court, in its name, pretty much supervises. It's a diversion program, and it's also a sanctions-based program. So with that, when you don't comply with drug testing and reporting, they have various sanctions that are imposed to maybe extra group time, to reporting to your pretrial service officer a little bit more. The extreme sanctions towards the end it progresses throughout. There's a phase process, and the more non-compliant you are, the higher the sanction could be. Like the most restrictive sanction may be jail time. So maybe it's like 3 nights in jail. So, of course, the goal is to comply with drug court, successfully completed, and if it's a misdemeanor, then your case will be no process, so the case will be dismissed. And if it's a felony, then you'll be transferred to probation. It's called a Star Hider program, which is pretty much the next step from pretrial is probation, where they continue through the process and continue going through the groups and the sanctions as well. The mental health diversion program is a non-sanctions program, which is very popular because the contrast is drug court and you don't have any sanctions. But you're signing a diversion agreement, and the goal is based on substantial compliance. So it's not as restricted as drug court. The goal, of course, is to remain substance use free throughout the whole process if substances are involved. But when the judges look at the cases as a whole, they're looking at the overall compliance, where for the most part, did you drug test negative? For the most part, did you meet with your pretrial services officer? Overall, did you comply with taking your medication or see your psychiatrist? So it's based on substantial compliance.
So, with it not being sanction-based, let's say folks don't do that, what goes on?
If they don't comply with their conditions completely, pretty much there's a certain amount of time where if you're just blatantly non-compliant with the conditions, the mental health court judge will send your case back to the original judge, and they would just go further with your case. You won't meet the requirements for the diversion program anymore.
This was an area with a lot of questions. In the back?
Does DC have a veterans court?
No, not yet. There have been talks about getting a veterans court, so.
In the front.
I'm just curious as to how quickly individuals are identified and how they're identified for the different courts. Who makes the decision about their entry into the different courts, and what's the time frame generally that all happens in?
Okay, so one of the previous slides talked about how things start in the pretrial process. So usually during arraignment, you'll receive a screener then to determine if you are in need of mental health services. in order to qualify for mental health court, you have to be supervised by the mental health unit. That's just one of the qualifiers. The original agreement was developed by the U.S. Attorney's Office, of course, because it's their agreement, but pretrial services had input, and so did the judges as well. So at the time of arraignment, there's a screening done to determine, the risk assessment is done, and then there's a screening done to determine if you're in need of mental health services. Not only in need of mental health services, but meet the criteria to be supervised in a mental health unit, meaning you have to have a severe and persistent mental illness, not just having a mental health diagnosis. If it's not a severe and persistent mental illness, you could be supervised in a drug court program. So at that time, you could be placed in a mental health unit, but overall, it's up to the U.S. Attorney's Office to determine if someone is eligible. And it's also based on criminal history. If you have a dangerous, and there's a criteria based on the dangerous and violent pending cases or convictions which can disqualify you for either diversion program, mental health court, or drug court. They try to flag it as early as possible to minimize your time of supervision, but sometimes it may take that initial court appearance outside of arraignment, and then they'll determine whether they're eligible or not, and then send the cases to the respective judges. So it could take roughly maybe 30 to 60 days just to land on that particular calendar. Then you start the process, because with both programs, you're not eligible for the agreement unless you're drug testing negative.
And so you can see, with the research that I was showing you that's come out in the last, 2 years about the impact of even 72 hours of detention, there's a lot of focus on how do we do the screening and referral and getting appropriate permissions quickly.
Now, are these individuals still in custody then while they're awaiting a decision, or have most of them been already released on
Yes.
bond?
Yes, for the most part, the goal is to release individuals with the least restrictive conditions, hence pretrial services. So unless it's your pending charge and your criminal history is severe, for the most part, individuals are released under the supervision of pretrial services.
And then a decision is made about.
Yes. They have the conditions that we'll monitor throughout the various units within pretrial, and then they just return to court, and then we'll make the determination of whether they'll be certified to the actual drug court calendar or the mental health court calendar. Question?
I just wanted to clarify. I think you answered, but I just wanted to make sure I understood. So the decision to release is made prior to the decision to defer? Is that what you're saying?
Decision to release someone.
To release, so if the person is in jail awaiting trial, the decision to divert or release, is that made prior to the decision to divert, or is it made at the same time? So in other words, if they're a diversion candidate and they're going from jail to community, is the decision to release pre-trial made before the diversion? Does that make sense?
Well, usually, initially what I saw is based on arraignment, and for the most part, if someone, at the arraignment, they determine whether someone is going to be held or released during arraignment. For the most part, individuals are released unless it's related to the actual pending court case. At that time, usually at arraignment, they may not necessarily know, because it is arraignment, whether someone qualifies for drug court or mental health court at that time. So it may take before the actual hearing. So they may be their conditions of release will release them of the pretrial status, but we may not know whether they're eligible for diversion at that particular time. So probably by their first appearance, usually when the U.S. Attorney will have their court information, they'll know by the first court appearance, which is probably within the next week or so, whether someone will be eligible for the diversion program, not necessarily at arraignment.
Release is made off a decision off of a risk assessment.
I'm sorry?
Their release is made off of a risk assessment.
Correct. The release is determined, and what appropriate program will be supervised. And in pretrial services, we have from high intensity to general supervision to possibly being released on your own recognizance and not be supervised under pretrial at all.
So then your secondary assessments, whether it's mental health or substance abuse, then make the determination into which court they would get put into.
And determine what level of services they may need within the respective units with pretrial, yes.
What screening instruments do you use?
We use a mental health screener that we kind of developed, and we use the ASI, the Assessment Severity Index. And the software we use to determine is AccuCare also.
Other questions focusing on release and diversion options? Okay, so again, sources of law will be your state constitutions. You can look at the NCSL database. That'll show your statutory framework. And then a lot of jurisdictions will have local court rules or agreements. The prosecutor will say, yeah, we're comfortable releasing these folks or diverting these folks. Informed judicial decision-making, very related. So what information does the judge have in front of him or her when they're making a release decision? What information does the prosecutor have? What information does the defendant have? Is this something that's optional? Do you want to talk a little bit about, well, I guess we did. We talked a little bit about the judge having access to a pretrial risk tool, as well as afterwards the mental health screener. And Glenda has made available the mental health screener that DC uses. We also see places using the Brief Jail mental health screen, which, if it's not on your thumb drive, is available publicly on the internet. So there are a number of tools that can be used to quickly identify whether somebody has a mental health need. There's just a question about staffing that. So any questions about informed decision-making? This was one of the meatier ones in our advisory group conversation, and so you'll see in the full document, it's a longer discussion, and would love to hear comments and questions as they come up. Mm-hmm.
One thing, it sounds like, and having worked in the mental health field in DC a long time, my experience at that time was that often defendants were not held pre-trial, at least not for long, typically. I guess maybe because of the volume, the amount of people, the amount of space in jail. That's not the case everywhere else. A lot of times there's more resistance, at least where we're coming from now. There's a lot more concern about releasing defendants pre-trial, especially if there are mental health issues involved. So I'm wondering, is my assessment of that correct? Or was it just the culture, the judges more open to pre-trial risk and using the tools that you guys have provided and the results of those tools, were they more open to that? Or do you think it was really just a matter of the high volume and the need to get people out of jail? Does that make sense?
Yeah, I think it's a combination of things. I mean, the goal, like I said, is to give the least restrictive. And of course, if someone has a severe criminal history and they have a pending matter, then initially, the charge initially would kind of warrant like a hold to determine what's going to happen, post-arraignment. But the goal, especially, you are correct with the mental health population, most judges really don't want to detain individuals with mental illness because they feel like having them in jail is not going to assist them, which for the most part is correct. So the goal is to, since we have a good relationship with the courts, to, for the most part, they won't just release them without any conditions of release. They will release them under the supervision of pretrial services, and then pick the appropriate unit, and then make sure, give them conditions that we supervise, whether it's placing them in drug treatment, whether it's connecting them to mental health services, or some other type of diversion where they may offer where you have to go into a program for school or employment readiness or things like that. So the goal is to make sure that they comply. And usually after a period of time, if you aren't compliant, then judges then, and also if you're testing positive, judges really have a hard time releasing individuals who've been testing positive for PCP or heroin, and now we have this large epidemic of individuals using synthetic cannabinoids. So the judges have a difficult time releasing individuals who've been testing positive. So.
Other questions about informed decision-making? The
about that, I just wanted to clarify that folks who are working the pretrial services agency, they're referring to them as officers. Are they probation officers?
Pretrial services officers.
So what kind of, what is categorized that for me? It's not behavioral health, but it's not law enforcement.
It's law enforcement.
It's law enforcement.
Yes, yes.
The National Association of Pretrial Services Agencies did a survey in 2009 of where pretrial services agencies are, and it's most common for them to be part of probation departments, but many of them are part of courts. Some of them are nonprofit, some of them are their own government agencies. So it really varies from place to place. Just uninformed decision-making, the Conference of Chief Justices, so that's the elite group of the state Chief Justices, has passed a resolution in support of, I think they call it smart pretrial justice, which includes pretrial risk assessment. So this is not radical for the it may be radical for the judiciary, but it is also bought into by the heads of the judiciary from each state. So there has been a policy paper by the Conference of State Court Administrators and a resolution by CCJ. So if this is something that you're talking to your judges about, that is a reference that might be quite helpful for them. And the National Center for State Courts has a set of resources on working with the judiciary around pretrial. Quick connection to needed behavioral health services and supports. We talked a little bit about this with the mental health screen, but can you talk a little bit about how somebody gets from court to working with a clinician? How does that connection happen?
So when we have our screener done, hopefully is done at arraignment, we'll have an individual screened to determine if they're in need for mental health services and eligible to be supervised in a mental health unit. At that point, the judge will release the individual and order the individual to report to pretrial services to meet with the pretrial services officer. Usually in the mental health unit, we have special training for the pretrial service officers. They don't necessarily need to have a mental health background because they're just a pretrial service officer, but we just give them the basic training to assist them with working with individuals with mental illness. And at that point, we would connect them if they're not previously connected. For the most part, individuals who are arrested have already been connected and received a mental health diagnosis. They may not be compliant with actual seeing their provider. So our goal is to connect them or reconnect them to services and monitor that. So if they have to take medication or if they have to go to groups, a lot of the programs are expanding now to have day programs. So we'll connect them to the day programs and just monitor their compliance and report that information to the court. We have a lot of individuals, because we're in the district, who they're Maryland residents or Virginia residents, so we actually have to, the DC services are for DC residents. So we've tried to establish as possible great relationships with Maryland and Virginia. It's a little bit more difficult because of proximity, of course, to connect them to services in their local areas so they can continue services even after their court cases are resolved.
How many pretrial officers do you have in your department?
In the mental health unit?
In the mental health unit and then overall?
In the agency, I'm not quite sure. In the mental health unit, it's 22.
22 in the
Yes.
mental health unit?
Yes.
Would you say it's about as many or like triple more than that in the other side?
No, actually, believe it or not, when the unit started about 11 years ago, there were just 9 pretrial service officers. So at that point, that means everyone throughout pretrial services had some individual that may have had, mental health services. So the program has, I guess, tripled since then.
What kind of caseloads do your officers have?
Right now, we're about 35. So for the most part, we're just providing case management, so we're just connecting them to services. We're not providing therapy or anything like that, but we do have an in-house program that we started a few years ago, which is a co-occurring intensive outpatient substance use program. So which is easier, so when you come down to see your pretrial service officer, you can drug test, and then you can go to groups. So, it's not a good thing when you have a pending court case, but at least you can maximize the opportunity. If you need substance use treatment, we can assist you with that. We can refer you to programs to get, your GED or, training services, medical assistance and things like that. So we have different units within pretrial that can assist you with different things. The agency continues to expand. We started out in one building, now we're at 3 locations within proximity of the courthouse.
Does the judge order the treatment?
Yes, we suggest it, but the judge will order it, so it's a little bit more stern coming from the judge versus for us.
This was a point of debate in the advisory group about exactly what role there should be in terms of ordering treatment, and programs around the country vary.
And depending of the drug, like I said earlier, when it comes like to PCP and heroin, the judges are kind of no nonsense. If you're a screener, if the ASI states that you need long-term treatment, the judge will order that. even to the point where some individuals are actually facilitated through the jail to get placed in treatment, where the judge will send the individual to jail and the treatment provider will pick them up from jail and transport them to actually get services.
Regarding community supervision and treatment, you have a number of resources through this conference about evidence-based behavioral health treatment for people involved with the justice system. There are a couple of resources on your flash drives. For pretrial supervision, I told you a little bit about the research out of Virginia supporting risk-based caseloads. There's also relatively long-standing research on the value of court reminders, whether they're postcards, phone calls, or text messages reminding people about their court dates. Are there other questions that people have about what community supervision and treatment can look like?
Are there good models that are out there for smaller communities?
Yes.
What about the role of trauma-informed care
Mm-hmm.
in this system? Is there one?
You want to take that, or?
Or harm reduction?
Actually, I actually mentioned this to Hallie recently. We're in the process of trying to get a grant that will assist us. We're getting with trauma training to assist the employees within pretrial services and a lot of the community-based agencies. So I think we're starting to recognize how important trauma is and how it's a need for everyone to have a full understanding to be able to provide services, and also the trauma that the individuals that we service. You know, we have a lot of individuals in the district who are just confined to their particular areas, who've never been outside of the District of Columbia. So the experiences that they see on a daily basis is traumatic, you know, losing family members, losing friends, and things of that nature, which leads to the high recidivism rate. A lot of individuals just continue to, you know, get involved in the criminal justice system. It's rare that I will see an individual that I hadn't in some form or fashion in my 15 years seen that individual before. You know, we don't have a lot of individuals that are not repeat offenders, and I think a lot of it had to do with the mental illness, the substance use, and the trauma.
In interviewing practitioners from around the country as part of this project, one of the things that came through so strongly was the programs that specialized, whether it was tied to a mental health court or not, special officers or not, but if they were mindful of the fact that they were working with individuals with mental illnesses, it truly informed both how the clinicians, the supervising officers, the attorneys handled those cases. We heard over and over again that understanding the context for these defendants helped the officers respond appropriately. So it wouldn't be an automatic back to jail if a court appointment was missed, because as Glenda was saying, the clinician might know that somebody was struggling with their medication, or they would be more thoughtfully adjusting the supervision strategy to understand the context that that person was operating in, whether it was difficulties with transportation, challenges in their personal life. The goal was really, how do you stabilize this person in the community so that they do come to court when they're needed, so that they are not committing new crimes. It really changed the approach to violations of pretrial release.
It's also an issue of the court system itself, not intentionally, but jail, reincarceration, re-traumatizing people once again. And nobody seems, and there's not knowledge about that from courts or from jails to understand their role in that re-traumatization. That's what's critical. So we're trying to help people that have a mental illness and co-occurring disorder and maybe lifelong histories of trauma, abuse, and what we're actually doing to them, what's being done to them by the system, is just putting them in a situation of over and over and over again being re-traumatized with these triggers. And there doesn't seem to be an understanding that's risen to the level that it, in my opinion, should be at this point in all the wonderful evidence-based stuff we have and research and knowledge, and it's so key to me. It's so key, and yet it's so hard to get that up front.
Yeah.
Men and women, the trauma, both men and women face.
So just for those who might not have been able to hear, a woman in the audience was talking about the importance of mindfulness about the trauma that many people have experienced, as well as the potential impact of the justice system in re-traumatizing those individuals, whether it's the courts or the jails. I know this has been a big initiative for SAMHSA, and there has been outreach to the judiciary about training for judges on trauma. And one of the, it wasn't under the heading of trauma, but one of the conversations that came out so strongly in the development of this document was about procedural justice and helping people understand how the justice system works and why it works the way that it does, so that that lessens the potential harmful impact, because if someone understands what's happening and can make better informed decisions, they have more of a sense of agency.
I was wondering if you could say a little bit more about what it really looks like for somebody going through the mental health docket. So the mental health docket's ongoing. You know, people are coming into it all the time. If there are groups that meet, do new people just come into that group on a regular, is this just a standing group that revolves and people are coming in and then they're going out and they're coming in and they're going out? I'm just wondering how that looks as far as consistency around treatment, or whether there's start-end dates, or whether there's, just how does it look for people coming through that process and getting services?
As far as mental health court is concerned, it's a revolving door. That individual, when the individual is eligible to be placed on the diversion agreement based on the criteria as far as compliance with mental health medication, or seeing their psychiatrist, or seeing their social worker, drug testing negative, once that individual is actually placed on a diversion agreement, that's when his or her process starts. We do have the program that I mentioned, the Building Bridges program, which is our in-house co-occurring program. That is a revolving door as well. Yes, but those individuals, there are a lot of individuals that are in the mental health court, they don't necessarily need substance use treatment, so it's just based on their compliance with mental health services. So the only time the process would kind of be halted is if there's a rearrest, and then there's a possibility of whether that case is eligible for the diversion program or not. But otherwise, the process is kind of individualized. Did that answer your question?
In the back?
You said something about if they're rearrested, then they can assess them if they're in a program, like they check with their community provider if they're meeting it. How do they know when they arrest them, the person's in the program, in the diversion program? The red flag.
If someone is already in the diversion program?
And instead of sometimes taking them to jail, they might just check with their provider, she said, about whether they're engaging in services, and maybe they can't get their medicine or something. How do you know when a police officer stops a person, how do they know they're in the program?
Well, they may not necessarily know once they actually get to court.
They might get brought into the booking process at least.
Yes, for the most part, that usually always happens, that when someone is usually arrested. Usually someone is released maybe like on a citation release if this is like not a criminal offense. But usually once they actually get in the courthouse and their pretrial services are the one who actually could conduct we call it a diagnostic interview. So at that point, we'll be able to tell if someone is being supervised in the mental health unit. We keep our documentation in our computer system, and we keep information up to date as far as like compliance information. That's all in our system, so we'll be able to report that information to the judge.
There's one more question here.
All right, I don't know if this will be an easy question to answer. Maybe I'm not even sure how to phrase it, but we were having some conversations recently about the role of pretrial services in actually providing some of these treatments or interventions. And I know there's a lot of, I'm sure, mixed opinions about that, but I'm curious as to whether this group that worked on these essential elements had opinions about it. Maybe that's fleshed out in the longer document, but you know, at least from our state, the pretrial services, I am hopefully not speaking out of turn, but struggle to get them into outpatient treatment programs. Either there's no programs available that meet that person's needs, or there's a wait list, or there's just a lot of barriers. And pretrial is generally a very brief period for some of these people.
Yeah.
So I guess my question, long story short, is what is the stance or the general feeling about pretrial actually starting to implement some of these interventions directly? Maybe not the medication piece or the therapy piece, but some of these other evidence-based interventions.
Well, pretrial services for the District of Columbia, we actually have the drug court program where we actually have in-house counseling. Well, the groups, we have the in-house groups, and actually everyone who the pretrial service officers are all certified substance use officers in the drug court program. So we actually have the drug court program, and we actually have a contractor that comes in and actually provide the groups for the co carrying track. So I think it depends on maybe on the agency, and as far as funding, I think funding is always an issue, and we do, because of our funding, we contract with a lot of the substance use providers, so we have a listing of providers, and we keep a certain amount of beds available. So, and that's how we're able to get people into the residential facilities. And again, with going back to collaboration, having a good working relationship with the core service provider in the district, we're able to connect them and keep an open line of communication, communicating with them, so they can call us and we can call them and let them know if someone is not compliant or not taking medication.
For those of you who have had questions about models other than the District of Columbia, I'm going to have my contact, you can contact me via the app. I'm Hallie, and I'll also have my email address up, and I'm happy to connect you either with programs I'm familiar with or with the pretrial services associations in the region that might be able to point you to somebody who's doing something similar to what you're interested in. Our last, most popular essential element is performance measurements and evaluation. Obviously, without data collection, measurement, and evaluation, we have no evidence-based practices, right? We're just guessing or taking our personal experiences. The National Institute of Corrections has a Measuring What Matters for pretrial services agencies. Our publication has a couple of thoughts about measures for pretrial focused on mental health. District of Columbia, this is where we all sort of shake our fists in envy about what DC Pretrial Services has in terms of research capacity. I'd love to hear a couple of words about it, and then we'll move quickly into a couple of minutes of thinking about what you'd like to take home.
Well, as far as our performance measures are concerned, we take great pride in our performance measures because, of course, we use our performance measures to report to receive our funding. So we talk about our appearance rate, the overall, because defendants are released under the supervision of pretrial services, so it's our goal to assist individuals with reporting to court so we can supply the court with that information. Connecting the individuals to mental health and substance use treatment. We have our screeners that we do, so we look at the amount of screeners that we do per year and how, based on the recommendation, are we connecting them to services, whether it's our in-house programs or to community-based providers. How many individuals who are actually held and released to us makes a difference as well. We have some individuals who are on the work release program based on their charge or their responsiveness to return to court. They may be duly supervised by Department of Corrections, which is work release and pretrial services. So the individuals, they come report to us, but they're being housed in a work release program. So our performance measures are extremely important, that we just keep up on them and try to do everything that we could do to maximize the overall compliance with our performance measures.
Great. I appreciate your patience through this session. I hope you're as excited as I am about doing work in this area. This is really, so many people move through the pretrial part of our justice systems. It is an incredible opportunity to be connecting people with services. It is also incredibly tricky, right? This is where defendants have tons of legal rights, as they should. So we have a lot of law, we have a lot of cutting edge social science in terms of what works for supervision. We have questions about, just as Glenda was saying, for these short periods, what sort of treatment is going to be most impactful, what's going to be stabilizing people in the community. We have a lot of energy here, a lot of foundations, the federal government investing in research, technical assistance. There's a lot you can do. I'd love for you to take a couple of minutes to think about what you've heard in the last hour and a half and something that you'd like to do at home, whether it's a conversation, getting in touch with me because you want to hear about other programs in your area, read the document on the plane home and tell somebody about it. Just a couple of minutes to think about that, and I will ask if we have a couple of volunteers who can share what they're going to do when they get home. Okay, can I have a couple of volunteers? Concrete things to do when you get home.
First, I just want to thank you. You are an excellent, very thoughtful facilitator.
Oh, thank you.
And I thank you for that. And your experience in DC is invaluable. So
Thank you.
I enjoy that. What I'm going to do is read all of the research. Well, not all of it, but a lot of it. And letting you know, I mean, I appreciate that information. And thank you for the presentation.
My pleasure, thank you. One more?
So we have an opportunity for a grant that is specific to pretrial services and also working with folks around the mental health court. So I'm going to be reading probably some of the same material you're going to be reading and hopefully pulling some of that together. But we have a pretty short timeline to get it out, and so we have a fairly collaborative group of individuals in our county that is working around our CIT implementation program. So getting a hold of many of the folks that are on that group and bringing them together around the table to get their input around that. It includes judges and DAs and everybody. So
Great.
it's nice that we have that core group already started and working together on other things.
Great. You know, the woman in the front was talking about reading, and also she's got a core group together to start working on a grant application. And we heard from so many that having the group together, it becomes a learning community. You're all reading together. Hey, did you see this article? I went to this conference. And so the process of working on that application or program development sort of builds its training into it. So kudos to you for that, and please let us know how we can be helpful.
Lots smaller than you.
It has been absolutely my pleasure to have you. This is my contact information. Again, I'm Hallie and I'm on the app. You have a treat in store for you in the ballroom. I understand Pete Early is going to be speaking. It is a treat. So we have a couple of minutes and then we'll be in the ballroom at 4 o'clock.